Greetings and welcome to USDA NIFA's Civil Rights webinar on non-discrimination on the basis of sex. My name is Jessica Creighton. I am the Senior Equal Opportunity Specialist with USDA NIFA. And this presentation is part of a series of webinars on various civil rights compliance topics. The purpose of today's webinar is to provide an overview of common Title IX compliance issues in NIFA-funded programs and activities. These types of Title IX compliance issues include discrimination on the basis of sex and sexual harassment, which is a form of discrimination based on sex. This presentation is divided into 3 parts. The first part speaks to discrimination based on sex generally and the requirements of Title IX related to discrimination based on sex. Part 2 focuses more specifically on sexual harassment as a form of discrimination based on sex. And part 3 of the presentation briefly reviews some of the ways in which USDA and NIFA exercise oversight responsibilities under Title IX of federally financially assisted programs, specifically those that are financially assisted by NIFA. This presentation is not exhaustive of all Title IX requirements and everything contained in Title IX. It is intended to focus a little more specifically on those issues that may be relevant to NIFA-funded programs and activities. I encourage you to think about, as we go through some of these requirements under Title IX, think about how they apply to the specific programs that you administer, whether those be agricultural research programs, whether those be extension programs or other education programs. Title IX of the Education Amendments Act is a comprehensive federal law that prohibits discrimination on the basis of sex in any federally funded educational program or activity. We usually think about Title IX in the traditional educational institutions and the traditional academic context of a traditional academic student attending a university or a college or an elementary or secondary school. But it's important to note that Title IX also applies to any sort of educational activity or training program that is operated by a recipient of federal financial assistance. So in the case of NIFA funding, for example, that would include not only a graduate student. This law would not only protect, for example, a graduate student working on a research project under a NIFA grant, which would be maybe a more traditional academic setting, but it would also cover a participant in an extension program because that is an educational activity. So again, thinking about this in terms of all of the programs and activity that NIFA funds, when we refer to admission, we are referring not only to admission into, for example, a graduate program or a graduate assistantship program or something like that at a College of Agriculture, we're also talking about admission into an educational or training program or activity. And some of the prohibited actions in the admission process, and these are all on the basis of sex, so I'm not going to repeat that every single time, but some of those prohibited actions of things that are prohibited to do based on someone's sex is giving preference to one person over another, applying limitations on the number or proportion of individuals of one sex or another, otherwise treating one individual differently from another, utilizing a test or other criterion for admission which has a disproportionately adverse effect based on sex, and this falls under the disparate impact theory of discrimination, is the concept in this bullet item, and recruiting at or utilizing a preference and admission from an entity which has students predominantly of one sex. Moving on to the provision of services and benefits, USDA's implementing regulations for Title IX state that a recipient cannot provide any course or otherwise carry out any of its educational programs or activities separately on the basis of sex, or require or refuse participation by any of its students on the basis of sex. And here we have several examples of different types of educational programs or activities. This is not exhaustive, these are examples, but you will see it includes things like vocational, technical, and adult educational activities, further underlining the point that this applies beyond the traditional academic context. Some of the actions that are prohibited on the basis of sex in the provision of services and benefits, and again, these are all on the basis of sex, so I will not repeat that every time, but you can see here on the list that it is included. And some of those prohibited actions include treating one person differently than another, in determining whether they satisfy any requirement for the provision of any aid, service, or benefit. So any requirement or condition that they have to fulfill in order to receive any sort of aid, service, or benefit. Providing different aid, benefits, or services, or providing those items in a different manner. Subjecting any person to different rules, sanctions, or other treatment. Discriminating against any person in the application of any rules of appearance, and otherwise limiting any person in the enjoyment of any right, privilege, advantage, or opportunity. Now, Title IX contains many exceptions and many exemptions to these prohibited actions. And again, because this presentation is intended for NIFA grantees, I did not include every single exemption and every single exception that there is in Title IX. There are, for example, some exceptions and exemptions for religious institutions or certain educational activities of religious entities. Also, specific entities are mentioned as being accepted or exempted. So there are other exceptions, but I think the most applicable exceptions that might come up are these. When we're thinking about either any sort of program, research, educational, or extension program funded by NIFA. And those include father-son or mother-daughter activities, as long as there are comparable activities. So you don't just have a father-son activity, but you have a comparable activity for each sex. Some athletic activities can be separated, such as contact sports or those involving competitive skill, as long as, again, there are comparative opportunities for each sex to participate in that type of athletic activity. Educational activities that deal exclusively with the topic of human sexuality can be separated. And this one is a big one, this last item, what we often think of as affirmative action activities. And these are activities that are intended to overcome conditions which resulted in limited participation by persons of a particular sex. So one example of those would be if you think about women in agriculture programs or women in agriculture activities, which are intended to address the fact that there is limited participation or some sort of an underrepresentation by women as principal farm operators in some areas. And so those affirmative action activities are planned and intended to overcome conditions, historical conditions, which resulted in that underrepresentation. I would encourage you that if you are planning such an activity, that you work with your Title IX coordinator to ensure that what you're doing fits into this exception or this exemption. And you want to be sure that you are basing the planning and implementation of such an activity on data that is local and applicable to the specific activity you're planning. That data should show that there is an underrepresentation locally in your state of a particular sex in the related field or the related area of study. So again, think about a women in agriculture program, which is developed because there are state Census of Agriculture numbers showing that women principal farm operators are significantly lower than the existence of women in the overall population. But again, that is something that is very good to work with your Title IX coordinator on to ensure that you are fitting within that exception or that exemption. Something that may also be applicable to some NIFA-funded programs and activities such as 4-H camps, and something that most of you probably assume is that separate housing on the basis of sex, as well as separate shower, locker, and toilet facilities may be provided. But it's important to note that Title IX does require that this separate housing or separate other facilities be comparable in quality and cost, and that they be proportionate in quantity to, that sex's representation in the participants. So important to make sure when you are doing that separate housing or that separate shower, locker, toilet facilities, that you make sure you have that comparable quality. Another note from our USDA implementing regulations for Title IX is that a recipient of federal financial assistance cannot provide assistance itself to any agency, organization, or person which discriminates. So, and this is considered aiding or perpetuating discrimination. And this is one of the reasons that we all utilize those assurances of non-discrimination with our subrecipients and our partners. But obviously also, if you are made aware of discrimination by a partner or a subrecipient, you want to make sure that you discontinue providing assistance to them or working with them so that you don't run the risk of violating this provision. Federally funded programs also cannot discriminate against or exclude participants based on pregnancy, childbirth, or a related condition. They also cannot implement rules regarding marital or parental status that treat students differently on the basis of sex. So this would be some sort of rule or condition that treats motherhood differently than fatherhood, for example. With regard to financial assistance, some actions that are prohibited on the basis of sex are providing different amounts or types of assistance, applying different criteria for financial assistance, and applying rules that treat marital or parental status differently based on sex. Now, there is an exception when we talk about financial assistance, such as scholarships and awards, that is related to scholarships that are established by wills or trusts or things like that. So if you do have a sex-specific scholarship or award that falls under this exception, again, I would just be aware of it and make sure you're working with your Title IX coordinator to ensure that it does indeed fall under this exception, this legal exception that is outlined by Title IX, to make sure that you are not running afoul of these prohibited actions. So moving forward to sexual harassment. Sexual harassment is a form of discrimination, sex discrimination, that is prohibited by Title IX. And under the requirements of Title IX, entities receiving federal funds have a legal obligation to protect students or participants in those educational programs and activities from gender-based violence and harassment. When we talk about sexual harassment, it's very important to understand what sexual harassment is. And sexual harassment can include a lot of different things, including things like physical acts of sexual assault, requests for sexual favors, unwelcome sexual advances or pressure, unwanted touching or physical contact. But it can also include things like discussion of sexual relations, stories or fantasies, jokes referring to sexual acts or sexual orientation, which are considered verbal harassment, sharing sexually explicit emails or text messages or photos, as well as what we call quid pro quo, which is explicitly or implicitly conditioning some service or benefit on the submission to unwelcome sexual activity. So it's very important to make sure that we're aware of all of the different things that fall under this umbrella term sexual harassment when we talk about sexual harassment. Harassment based on the fact that an individual does not conform with sex-based stereotypes of masculinity or femininity is also covered under Title IX. So this means that you cannot harass someone because, for example, the way they dress, maybe the way they talk, maybe their hobbies, or even their profession, or anything else about them is for some reason not in line with your stereotypes of what masculinity or femininity is. And any such harassment of that nature is considered a form of sexual harassment under Title IX. When we talk about sexual harassment, a lot of times we focus on how sexual harassment complaints are handled. And I do have that here at the bottom of this list because it is important, and it is also, an aspect of preventing future sexual harassment issues is responding correctly to harassment concerns and complaints. But at NIFA, we really want to stress this idea of proactive prevention of sexual harassment. So it's not just that you are responding timely to and taking seriously all sexual harassment concerns and complaints, which is of course important, but that you're also taking measures to make sure that sexual harassment doesn't happen in the first place. And you can do this by providing consistent and regular training to all of your faculty and staff on Title IX issues, by having that clear sexual harassment policy and grievance procedure that is updated periodically, by making sure that you notify everyone, students, participants, faculty, and staff regularly of this sexual harassment policy and of the grievance procedure. So you don't just have a policy and a grievance procedure that exists, but no one is made aware of it, but that you're actually notifying people that, on a regular basis, that this is our policy and this is our grievance procedure. And then also making that information public and easily accessible. Planning awareness and outreach activities also on sexual harassment issues can be very important in this proactive prevention stance. It's also really important to make note of the fact and explicitly state in your guidance, in your sexual harassment policy, in your grievance procedures, and in your training that Title IX, just like all other civil rights laws, prohibits adverse action against individuals who exercise their rights under these laws, in this case under Title IX. That means that if someone files a complaint under Title IX, whether that be a sex discrimination or a sexual harassment complaint, they cannot suffer negative consequences because they did that. So someone can't, be fired or be demoted or be denied a promotion, or, a participant can't be barred from participating in future extension activities if they file a sexual harassment complaint. And making that explicit and making that clear is really important, especially in the sexual harassment content, in this sexual harassment context, because it, allows people to feel more free to come forward and not to feel intimidated with, the possibility that there will be some sort of adverse action or retaliation after they raise a sexual harassment concern. It's really important as a NIFA-funded program or activity, whether you are an agricultural researcher, head of an agricultural research program, or extension administrator, that you work with your university's Title IX coordinator or Title IX office to ensure that your programs and activities are included in Title IX policies, procedures, and guidance. Again, a participant in a non-traditional academic setting, such as an extension activity, is covered under Title IX, and you want to make sure that your university's policies, procedures, and guidance include that as a possible scenario and a possible complainant and someone who might need to utilize the grievance procedure. Make sure that your research staff and faculty get the Title IX training that they need. Make sure that your extension staff know how Title IX applies to planning and implementing extension activities, in terms of separating and doing separate activities on the basis of sex and how that's prohibited. And make sure that those lines of communication are open with your Title IX coordinator or your Title IX office to get advice and to problem solve. Lastly, I wanted to speak briefly about USDA and NIFA's oversight of programs that receive federal financial assistance from USDA and NIFA, specifically our oversight with regard to Title IX. So the first major way that USDA has oversight over NIFA-funded programs and activities is the discrimination complaint process. And I have here two links that you can find by searching these phrases on the USDA website. And also, once this is made available online by clicking on the PowerPoint slide, you should be able to access this link. But there is extensive information on this USDA page about how the discrimination complaint process works, as well as the discrimination complaint form that individuals can use to file a complaint with the USDA. But essentially, it's important to note here that anyone who participates in a NIFA-funded program or activity can file a sexual harassment or sex discrimination complaint with the U.S. Department of Agriculture. And this is separate and distinct from your university's grievance procedures, that they have this right to file a complaint with the U.S. Department of Agriculture for USDA to investigate within 180 days of the allegedly discriminatory incident. That means that if a graduate student, for example, feels that they've been harassed within a research program that is receiving funding from NIFA, that individual can go directly to the U.S. Department of Agriculture and file a complaint. These complaints can be filed with USDA via postal mail, fax, or email. And here is the information to file via those methods. The second major way that USDA and NIFA have oversight of under Title IX of our funded programs and activities has to do with our regularly scheduled civil rights compliance reviews, which are systematic reviews of many different civil rights areas Review area 6 has to do with non-discrimination on the basis of sex. And here are some of the things that we look at. You'll see that these items that we look at under this review area, including what your Title IX training looks like, how sexual harassment complaints are handled, and things like that, that these are all tied back to and related to the requirements under Title IX that we discussed in parts 1 and 2. But this is a major way that we fulfill our oversight responsibilities with regard to the programs and activities that we fund is through those compliance reviews. Finally, there are some additional Title IX reporting measures that we've recently implemented. And these include a requirement that NEFA Equal Opportunity staff be notified after an administrative or disciplinary action is taken as the result of sexual harassment concerns and or complaints in a NEFA-funded program or activity. We've also instituted quarterly reporting requirements on not only complaint numbers, but outreach and training activities that are done. And finally, we have implemented regular quarterly meetings between Title IX coordinators and NEFA USDA. The most upcoming ones are in April of 2021 and July of 2021. And those are to open up the conversation and dialogue about Title IX needs at our universities. So that is it for today's presentation. I would encourage you to reach out to me via email or phone if you have any questions or concerns related to Title IX compliance or any area of civil rights compliance in a NIFA-funded program or activity. I am happy to respond to questions via email or set up time for a conversation to provide technical assistance. If you want to join our civil rights listserv, that's where we send out information about civil rights guidance, as well as any information about upcoming webinars or other upcoming working groups or other resources related to civil rights. You can join the listserv by contacting my colleague Lydia at this email address that's here. In the meantime, thank you very much for joining and viewing this webinar today. I encourage you to take advantage of our other webinars and resources, and again, reach out to me if there are any outstanding questions or issues. Thank you so much and have a great day.